Good afternoon, everyone. Thank you all for joining us today and welcome to our webinar. My name is Samir Varma. I'm a partner in Thompson Hine International Trade Practice Group. I guess first off, we wanted to wish everyone good health and hope you all are safe and well during this time. And before we begin, I just have a few housekeeping items to go over. Today's program is being recorded. We will send a link to all attendees within 48 hours of today's presentation. If you have any questions during today's webinar, and I hope you all do, feel free to use the question box located in the control panel on the right side of your screen to submit them. We'll try and answer as many questions as we can at the end of the webinar. You'll also notice on the right side in the handout panel, you can download a copy of the PowerPoint slides and bios for today's speakers. Thanks again for all your interest. Today's webinar is session 2 of our 4-part series leading up to July 1st, when USMCA officially replaces NAFTA. Each Wednesday at 2 p.m., we'll be joined by counsel in Canada and/or Mexico to discuss how companies can navigate certain USMCA provisions and also understand the rights and obligations of the member countries. Last Wednesday, the discussion focused on labor and employment protections. Next Wednesday, 24th, we will address trade facilitation as well as some practical questions. And our 4th and final session will take place on July 1st, when we will address supply chains, including issue spotting and tips and best practices for maximizing USMCA benefits. So as I mentioned, in today's session, we will be addressing USMCA's new government procurement commitments. I'm delighted to introduce our panelists. Joining me today are Marcia Mills, counsel with the Canadian law firm Fasken. Marcia has over 20 years of private and public sector experience in procurement, government contracts, and security, and is currently located in Fasken's Ottawa office. Also joining me today is Tom Mason, partner and practice group leader of the Government Contracts Group at Thompson Hine. Tom focuses his practice on all aspects of government contracts law and litigation, including dealing with grants and cooperative agreements, the management of major government systems and programs, and the resolution of related claims and disputes. So we'd like to now start the substantive portion of our webinar. Again, if you have any questions, please use the question box on the right side of your screen, and we'll save some time at the end of the webinar to answer as many questions as we can. I'd like to turn the presentation over to Marcia, who will start with the Canadian perspective as well as some coverage issues. Marcia, the floor is yours.
Thank you, Samir, and thank you for everyone attending today. When we first became aware that Canada wasn't going to be party to the USMCA Government Procurement Chapter, I was strolling around the office telling everybody, this is a big issue for me, and my commercial counterparts at the firm were kind of confused about why I was so interested in this. So I thank you all for attending. As far as the Canadian, we've got the slides up. I'm just going to divert a little bit because I think the initial question everybody has is, what does it mean generally if Canada is not part of the government procurement chapter under the USMCA? Canada's official position on this was very circumspect, and I think it's probably because there were a lot of other issues that we were negotiating and that we were concerned about that were very much reported in the press. So this particular, the fact that we weren't going to be part of Chapter 13 wasn't really commented upon, and in fact, Canada hasn't said much about it other than identifying that going forward, the US and Canada will maintain their trade access under the World Trade Organization Agreement on Government Procurement. So I'll be calling that the WTO AGP, or the AGP as I talk through today. And then as between Canada and Mexico, the Comprehensive and Progressive Agreement for Trans-Pacific Partnership, quite a mouthful, also known as the CPTPP, would allow Mexican business and Canadian businesses to have cross-border access to procurement. The other position that the Canadian federal government took was that the WTO AGP is, quote, a more modern trade agreement in its approach on market access than NAFTA was, and it provides improvements to the commitments that we made under NAFTA. So that's the official position of the Canadian federal government. Also to note is Canada is very much a trade agreement friendly country. We're currently subject to a multiplicity of trade agreements. There's at least 15 international trade agreements we're subject to, another handful that we're negotiating. Plus we also have an internal trade agreement, the Canadian Free Trade Agreement, which is between the federal government and the provinces. So it's important to keep that in mind, particularly for US-based companies who may have a Canadian operation, because if you're a supplier located in Canada, even though your parent company is in the US, you get the benefit of the Canadian Free Trade Agreement as well. So it's true that, as I said, the WTO AGP does reflect current procurement practices such as electronic tendering, which of course came into being after NAFTA was originally negotiated. But there are some distinctions to note, and in the slides we run them through as the who, what, and when. So the first issue is on who's covered. Well, what's the same on the coverage between what is in NAFTA currently until July 1st and what's under the WTO AGP is that entities that are going to be covered have to be listed. So there's no automatic, if you're a government entity, you're included in a trade agreement. One thing I will note, which is similar in all trade agreements, is it doesn't necessarily, the coverage isn't necessarily determined by who's doing the purchasing necessarily. And that's, of course, a mechanism that all trade agreements have to avoid circumvention of the obligations. So in Canada, we have federally two main departments, Public Works and Government Services Canada, which has now been rebranded as Public Services and Procurement Canada, PSPC, and Shared Services Canada. And those two departments, under their legislative authority, do the majority of the buying for the Government of Canada. They are both covered in all the trade agreements. However, even if they weren't, if they were buying from another department. So for example, if Public Works was buying for the Department of National Defense and the Department of National Defense was covered by a trade agreement, the coverage of the trade agreement would still apply. The only difference generally at the federal level under the WTO AGP and NAFTA is that under the WTO, the Department of Transportation or the Department of Transport is included with a limited list of purchasing goods and services that they're purchasing, and they're all available to you in slide 1. Now, what's the difference? The most significant difference between the two is actually quite beneficial to U.S. businesses. And that's because under the WTO AGP, sub-central government agencies are now covered. What that means is it's provincial and territorial governments. So that's quite an expansion. And that coverage also exists under our national agreement, the CFTA. It exists under the Canadian European Economic Agreement, or CETA, and also under CPTPP. So although the procurement capacity is moving away and Canada will not be under the government procurement chapter under the USMCA, it remains under the WTO AGP. Plus, there's always been this access to goods and services and construction services procurements at the sub-central level. So if we can just go to slide 2. So now the what. What's the same? Goods and services and construction services all remain covered. The difference, as we note in the slide, is that I usually refer to NAFTA as a by exception agreement. So goods and services are covered under the various categories that are listed unless they're specifically accepted. So a party negotiating NAFTA has said these particular goods and services or construction services aren't covered. Under the WTO AGP, it's the reverse. I call it by inclusion trade agreement. So we still have the list and the types of goods and services, but they have to be specifically identified in the various annexes that are included by all the various parties to the WTO AGP. Now, the one difference that you'll take note of, if you haven't already, is under the WTO AGP for the sub-central government, so again, our provincial and territorial governments in Canada, we've exempted out procurements that are being done for regional socioeconomic development, for highways, or for distressed areas. So that is kind of an exclusion for the sub-federal level, because that's within each province and territory's own exclusive domain to determine that where they're doing socioeconomic developments for an area that is socioeconomically depressed, those types of procurements are not covered. And what's the same? Also, the thresholds apply. So even if a government entity and the goods or services that they're buying is covered, if the purchase is below the threshold, the trade agreement will not apply. So the big issue there is, what are the differences in the thresholds? And as you'll see on our slide here, for construction services, the thresholds are actually lower than they were under NAFTA. So it was 14 million Canadian under NAFTA. Under WTO AGP, it's around 9.1 million. And that is the same both federally and at the sub-central level. So if we can just pop to slide 3. Thanks. Goods and services thresholds are higher, of course. So federally, there's quite a jump. Under NAFTA, it was $32,000. It's now under WTO AGP, you're up in the $238,000 range. The sub-central agencies, the sub-central groups, provinces and territories, are quite a bit higher at $649,000. And then there's another category called other entities, which is at $650,000, which is the figure we've provided there. That's, for example, a crown corporation or someone who doesn't, or an entity that doesn't fit in a distinct federal definition. For services, there's also an increase. It's just about doubled. It's gone from $108,000 up to $280,000 or $238,000. But note that with your sub-central agencies under the WTO, they've retained the same higher threshold. So I just want to go, and as you note on the slide, as I mentioned earlier, under the Canadian Free Trade Agreement, the thresholds are very much lower in Canada for any Canadian-based suppliers who are bidding on goods and services. So a little bit of a side discussion. The principles between the two trade agreements are still the same. The procurement rules that come out of the trade agreements haven't really changed if you're going under NAFTA or you're going under WTO AGP. So for example, in Canada, the general duties of fairness, good faith, openness, and transparency that come out of the trade agreements are all still going to apply. So a party to a trade agreement must still implement processes that guarantee fairness and impartiality of the process, that maintain the confidentiality of the bids. They have to maintain the open and transparent process of a procurement. They must provide what we often refer to federally as the level playing field on which bidders compete. What that means is all bidders are treated equally. It doesn't mean the outcome of the procurement, of course, is going to be the same, because not all bidders will be able to meet the requirements, but definitely they all have to be treated the same. In addition, non-discriminatory processes. And what that means is, of course, if a party who's a signatory of the trade agreement tries to set up a procurement where it discriminates against parties from another country or from another trading partner, that's prohibited. Unless, of course, you're able to and we won't get into this today, of course, but unless you're able to fit your procurement under one of the exceptions, for example, the one that everyone will be more cognizant in this, in the current climate, is a national security or a national defense exception, where you can remove yourself from the principles of the trade agreements. Also in Canada, because competition is the default unless an exception applies. And Canada very much takes an open process to public tendering. You're going to see that procurement is generally, I don't think, going to change too much because we have so many other trade agreements. We have the WTO AGP. Public procuring entities still have to remain fiscally appropriate. So they still have to stay in budgets. They still have to achieve good value for money or meet other financial objectives. They still have to stay consistent with government priorities. So they have to take into account when they procure a whole of government perspective in Canada, for example. They still have to conduct the procurements fairly and consistently with their own policies and other trade obligations, and they still have to achieve social policy and economic benefits. One of the things I will note is that in Canada, we are seeing more of a pre-qualification process coming into procurements, and I realize that that's not quite in line with what we're talking about today, but I did want to mention that with respect to pre-qualification, as you probably already are aware, the trade agreements also provide rules and how you can conduct pre-qualification. So those rules that generally have been applying if you've been participating in Canadian procurements are going to stay the same. So the one other thing I wanted to bring up is that in Canada, the one difference, but this has always existed for Canadian public suppliers, is the dispute process. If you are an aggrieved bidder, if you feel you've been discriminated against in a procurement, the dispute mechanisms still remain in Canada, and I do like to always note that in Canada, particularly with the trade agreement, we take a very limited perspective. So all trade agreements are required to have an administrative or a judicial review procedure available for bidders. However, the only entity in Canada that has implemented an administrative review process is the federal government through the Canadian International Trade Tribunal. They hear complaints with regard to federal procurements, and I will tell you the numbers are low. There's only about 60 to 70 complaints per year. So the general atmosphere in Canada is people don't tend to formally complain all that much. At the subcentral level, although the parties, as they've been covered by CETA and originally under the WTO AGP, we're also supposed to have an administrative or judicial review. The process is much less formalized, a lot more circumspect. So in 2019, the provinces of British Columbia, Alberta, Manitoba, and Saskatchewan developed a bid protest mechanism that allowed suppliers to bring forward complaints. To date, there have only been 3 complaints. Our firm held 2 of them. We took the approach at the bid protest mechanism, and this is before an arbitrator. We took the same formal approach that we use in front of the Canadian International Trade Tribunal, and did quite well on that front. I think in Canada you will not have arbitrators at this point in time who have good trade law experience. So to the event that you're doing a bid protest mechanism in the 4 Western provinces, you do want to ensure, of course, you have counsel who understand the trade agreements and they can guide the arbitrators. Ontario, another big buyer in Canada, they do offer a protest process, but it's a non-binding dispute. And in all cases, cost recovery is very limited. So what that leaves you with in Canada is you can either go through a non-binding process at the sub-central level, you can go to the CITT federally, or you're heading off to the courts, either seeking a judicial review of the decision or a general claim for damages. In those cases, we don't have a huge body of law in Canada. In fact, it's minimal at best with regard to courts interpreting trade agreements. So on that front, it will be interesting to see if it starts to develop any further. But as I say, we have very limited case law in Canada with regard to trade agreements. I think at that point, Samir, I will stop this part of the presentation and hand it off to Tom.
Sure. Tom, the floor is yours. Help us out with understanding the U.S. perspective on all this.
All right. I guess if we can turn it over to the slides that deal with the USMCA. Let me first tell the audience, thank you for attending, and it's nice to be able to speak to you. My background is in public procurement, as Samir said, and so I look at this new treaty from a public procurement perspective for today's purposes. And my job is to talk to you about Chapter 13 and the provisions that are contained in Chapter 13. Sometimes the words change, but the practices will remain the same. And I think that's the theme that I like to think about when I look at this particular chapter. There are going to be different procurement rules within North America, within each country. So that's a given. We start with that. And as Marcia just mentioned, the U.S.-Canadian relationship will be governed by the WTO GPA. And I'm not so sure that I think I agree with Marcia. I'm not sure there's going to be too big of a change here. And the procurement between Canada and Mexico is going to be covered by the CPT EP. And so, from a public procurement perspective, Chapter 13 really governs cradle to grave, and this particular chapter really sets forth standards, and it sets forth things that the parties, the nations aspire to achieve, not so much the specific rules and procedures that are going to be followed, although they are there in many of the exhibits. Next slide, please. So this slide is probably not all that helpful from your first looking at it, but I just put the topics out there just so that as you look through the slides after our presentation, you can see the scope and the breadth of Chapter 13. It's really a cradle-to-grave type of a treatment, and there are many annexes and appendixes in each one of the articles. Everything is covered here, from definitions to how we're going to use particular subject matter experts. A couple of key provisions I like to look at are in the middle, Article 13.7 and 13.8. I mean, 13.9, I think, get into the heart of procurement. And these are things that I think that practitioners need to focus on as we think about USMCA. One of the things that I would note that is common in all the statutory schemes is the desire to negotiate differences, but also transparency. Transparency is very important because with all trade agreements, compliance is key. And so transparency and what all the contractors do and say and think, and all the agencies, transparency is required in what the tender looks like, how it's restricted, what rules are going to apply. And and what rules are going to apply, and all these things are going to be laid out pretty. Next slide, please. The next slide deals with, I'm getting a message about people not being able to hear me. I'm not sure what to do with this. I'm going to try to click a mute button.
Hey, Tom, this is Samir. We could hear you. We could hear you before you press mute just there, so you might want to unmute your phone. Hey, Tom, I think you're on mute right now. You might want to go ahead and unmute.
Okay, now I'm back on mute. So For all of you who have sent me messages, I really appreciate it. They've gone in different directions, but at any rate, I do apologize for not being able to be heard well. Qualification, I think, is key, and essentially, we want to make sure that all of the participants in the procurement process are qualified. And one of the things that we see here is the requirements for qualification. And they pretty much mirror the current requirements, but I want to make sure that we talk about there. We're talking really about the ability to do the work. Certainly, you've got to be certified in the supplies or goods and services have to be conforming goods and services, and to the extent that there are appropriate licenses and that need to be obtained, that's a regulatory requirement. But what the focus here on in 13.7 is what we would call responsibility. And present responsibility is very, very important in American procurement law, as in the other countries' procurement law. And this is stated in 13.7.3 is responsibility in terms of being financially capable, and also responsibility to be able to perform the technical requirements of the contract, or to provide the supplies that meet the requirements of the supply. And this is going to be laid out in the tenders, in the solicitations, this requirement. And so not only this requirement, but the other requirements of the solicitation are going to be evaluated in terms of who gets the award. And so a company that has been performing well under the USMCA is going to have to demonstrate in their solicitation response why they are responsible, why they are meeting the terms of the solicitation, how they're meeting the terms of the solicitation, and how they're going to complete the contract. And this is going to be one of the conditions of award. And so the USMCA, I think, something that is uniformly required right now, but I think there's going to be maybe a bit of an emphasis on present responsibility, both financially and technically, in terms of getting an award and being able to perform the award. And let's go to the next slide. And the other thing that I wanted to speak to, what USMCA speaks to very clearly is any dispute we're going to negotiate. This is one of the things that I think is pretty important. And also, there's going to be a high requirement for procurement integrity. And I look at this provision in Chapter 13 in terms of understanding that there's going to be administrative remedies, there's going to be contract remedies, there's going to be court-imposed civil and court-imposed criminal remedies for violators of the procurement integrity provisions that are required in USMCA. And so, for instance, in a U.S. procurement, a contractor that doesn't meet the standards or doesn't comply with performance can be suspended from further contracting, or can be debarred altogether from contracting. If a contractor makes a false statement, that contractor can be not only given a contract sanction, administratively barred, but could also face some civil penalties that would be imposed by a court. Now, the countries have policies and procedures in place to address conflicts of interest, and so the main focus here is going to be on appropriate disclosures of those conflicts. And lastly, I have for the final bullet here is that we can look at all the different provisions of Chapter 13 and all the requirements of Chapter 13. And the one thing that jumps out to me is the focus on internal controls, ensure appropriate performance, programs to promote compliance and business ethics, standards of conduct ethics, and also a program to prevent, detect, and report corruption, fraud, non-performance, and general and malfeasance of a contracting party. And so all of this is a built-in requirement in Chapter 13. I would say that by my perusal of all the requirements and all the chapters, all the provisions of Chapter 13, there's not a large difference in the way the requirements are laid out. The difference is what provisions are going to apply to each respective country, and then the differences will be with the administrative and governmental offices within each country. And so, with this, I think I'll turn it back to you, Samir, for any questions.
Sure. Thanks, Tom. Marcia, I think we'll start with you. And I know you touched upon this a little bit during the presentation, but what exactly happens to different procurements that are underway and subject to NAFTA but aren't necessarily concluded before July 1st?
Sure. In some chapters of NAFTA, there are what I'm going to call transition provisions or transitions. For example, under Chapter 11, Investor State Dispute Resolution remains available for disputes in process. However, the procurement chapter does not have, a transition, a carryover provision. So upon NAFTA no longer being operative, if a procurement was subject to NAFTA and it's not yet finished, the NAFTA influence, and I would expect the government would take the position that NAFTA is no longer there. It doesn't exist. Therefore, the principles of NAFTA don't exist. And I'm just going to put a pin on that for a sec. And then for an awarded contract in Canada, our federal trade, the CITT has been very clear that once you've gone through and you've awarded a contract, the influence of the trade agreements post-contract award are minimal at best, because now you're into elements of contract management. There are some situations where, immediately post-contract award, for example, if the government awarded a contract and then decided to renegotiate the whole thing and remove a whole bunch of mandatory obligations that were supposed to be part of the contract and were immediately negotiated out, I'm quite certain an aggrieved bidder who had perhaps been excluded from the competition based on these mandatory provisions that have suddenly disappeared could raise a complaint to the CITT and raise that particular issue. However, as I said at the outset of the presentation, Canada is just trade agreement rich. So even if NAFTA no longer applies, you will have, to the extent the goods and services are covered, you would still have your WTO AGP rights. And as Tom noted in his slides, the rules that come under the USMCA for fair, open, transparent procurement, bidders having the necessary financial and corporate capacity to take on a procurement, issues with regard to fraud, conflict of interest, bankruptcy, all those elements still remain within the procurement. So for a U.S. entity who's bidding on a procurement, even if the WTO doesn't apply, it's very likely that another trade agreement is still applicable, and so the procuring entity will continue with the process in a trade agreement compliant manner.
Thanks. Tom, similar question. So even though you noted that some of the provisions of USMCA related to government procurement is relatively similar to those under NAFTA, I mean, what's the status of contracts that were awarded under NAFTA once NAFTA is replaced?
The way I would answer that question is, for me, the 30 June is it. If the contract is completed under NAFTA, awarded, and it's going to be performed under NAFTA, by and large, that will be the case. If there's a major change to the contract 2 days later, that would present a question and something that have to be resolved. And so we look at the line of demarcation is pretty clearly the 1st of July. On the 1st of July, USMCA will apply, and the provisions of UCM USMCA will apply, and if the contract good was awarded under the NAFTA contract, the NAFTA provisions will apply, and or can continue to apply during contract administration until the contract is resolved. Now that doesn't mean that the contract can't change and to include different terms, and we suspect we'll see some of that. But generally, we're looking for, in the U.S. at least, we're looking for a pretty clear line of demarcation. The government at the federal level, the government agencies are beginning to give guidance as to how to perform contract administration during this time of transition.
Okay, great. Marcia, you mentioned dispute processes a little bit during your presentation. So, what dispute processes are available under the various trade agreements that Canada is a party to, and even for procurements that are not covered by the trade agreements?
Sure. So all trade agreements that Canada is signatory to require the parties to have in place an administrative or judicial review procedure for bidders, like I mentioned. There are provisions in the trade agreements to deal with instances where a bidder may not have a direct access so that the party, the signatory home country, could bring a dispute. But in Canada, there's no prohibition on bidders bringing complaints. As I mentioned as well, federal government, we have the Canadian International Trade Tribunal in place. It's been running for decades. It is considered an expert tribunal in Canada. As I mentioned also, subcentral level bidders are left to struggle a bit more because of the nascent nature of a lot of the bid protest mechanisms. We have our 4 Western provinces that have started on a bid protest mechanism. We have an informal process in Ontario, but otherwise what that leaves bidders under trade agreements is if they can also bring a claim within the judicial system. So a trade agreement dispute mechanism, even at the CITT, is not an exclusive mechanism. But keep in mind that if you are going to use either the CITT or a provincial dispute mechanism, they all apply the minimum time period for raising a dispute that is set by the trade agreement. So that's 10 days from the date at which the bidder knew or reasonably ought to have known it had a complaint. So the time to raise a complaint by bidders is very short, and at the federal level, at the CITT, they enforce that really strictly. There's not a lot of leeway there for extending the period. If you should have known, then you should have complained. You can also raise a matter. You can either bring a judicial review at the federal court, or you can bring a general claim for damages in the superior courts. What we're seeing a trend is a bidder will raise a complaint at the trade tribunal and concurrently raise a judicial review complaint at the federal court, because the disclosure obligations under each of those dispute processes can actually trigger your ability to get at even further information and further evidence if you believe that you've been wrongfully excluded from a bid, or you should have been awarded the contract and you were not. Under the CITT, they have very broad disclosure obligations, but there's also additional disclosure obligations at the federal court. So that's kind of a strategic shift we've been seeing the last while with regard to disputes. In Canada, we don't have a government accountability office equivalent or a federal court of claims. So if you're not covered by a trade agreement, you would have as your remedy, of course, the direct lobbying, the direct trying to deal with government officials. Otherwise, you're seeking a remedy in the courts. Again, either a judicial review of the decision as an administrative decision, or a claim for damages within the courts.
All right. Well, then, Tom, follow-up question for you. I mean, under USMCA, you have the investor state dispute settlement system. How does that compare with what Marcia was saying under the different dispute settlement systems. Oh, Tom, you there? Might be on mute again.
I am here. I didn't hear the last part of your question.
Oh, I was just talking about the investor-state dispute settlement system under the USMCA, and which is in contrast to what now Canada will be able to use for these government procurement provisions. And I just want to get your thoughts on that.
Yeah, I think that that's one of the changes that is viewed by many to be a good change, is that the investor dispute settlement system has been a hot topic for sure, and it gives a party a right to sue under the treaty. Most of the disputes in contracts that we see involve courts or administrative boards. And so the ISDS is going to be done away with under the USMCA. So in my judgment, for the vast majority of cases, nothing's going to change, because there's going to be an administrative, a state or federal administrative office that will be handling contractor status. There'll be administrative tribunals that will resolve contract disputes. There are courts that will resolve civil and even criminal disputes. I think that Chapter 13, the importance of Chapter 13 is it doesn't specify any particular tribunal or any particular process to use. It just says that the parties have to agree on that. And that's got to be part of the solicitation. And so there's a real focus on Chapter 13 on the solicitation, the tender that the governments give out, and that the bidder responds to all the terms of that solicitation, and that the bidder has an effective understanding of how a protest will be handled, whether it be administrative or through a tribunal at the local, state, or federal level. What options are available to bring a lawsuit. And then I think the other thing that's important to note, it's really important as to whether or not the challenge is to the provision of the treaty, or if the challenge is to the provision of a contract in which the treaty was applied. And the vast majority of cases that we see, it's the latter. It's the contract and the way that the provision's applied. It's not a dispute over the term of the treaty. It's the way that it's applied, and therefore your tribunal resolution seems to be at a lower level. And so I think this issue of who gets to be sued and in which fora should they be sued in is pretty much left to the agencies and the bidders to make sure that it's put in the solicitation, and then that process is followed during the performance.
Thanks, Tom. And I see that we're up against our time, so I just want to note that if anyone has additional questions after the webinar, please feel free to email one of us or your current Thompson Hine or Fasken attorney, and we'll try to get your thing answered. In closing, I really want to thank Marcia and Tom. Appreciate you participating on today's webinar, and thanks everyone for attending. A friendly reminder, next Wednesday at 2 p.m. Eastern, we'll be discussing trade facilitation and practical questions, where we'll be joined by attorneys from Fasken, as well as the Mexican law firm Santa Marina and Steta. We invite you to go to the Thompson Hine website and register for this event, as well as to sign up to receive our mailings under the Publications tab. One quick plug, I encourage you to visit our blog, trumpandtrade.com. You can sign up there to receive timely updates on the Trump administration's international trade activities and policies. Thanks again, everyone. Please enjoy the rest of your day and stay well.